I'd like to talk to you this afternoon about some pending legislation that is now before the Philippine House and the Philippine Senate, particularly House Bill number 6122 and Senate Bill 1591. Both of them would commonly enact a law that would be known as the Internet Transactions Act. Now, the purpose of the Internet Transactions Act is to establish a unitary basic regulatory framework for e-commerce in the Philippines. There's no existing law that does this. There have been not even the e-commerce act or the existing e-commerce act, which was designed primarily to establish a basis for legal recognition of electronic documents in the Philippines rather than to regulate the particulars of e-commerce, as especially they have emerged in the current day. Now, since there is no unitary law that attempts to regulate e-commerce itself, questions have arisen because multiple of existing regulatory agencies could possibly exercise jurisdiction over different or various aspects of e-commerce based on their existing mandate. So there is a perceived need that the regulatory structure that would govern e-commerce in the Philippines should be clarified. And that is one of the intentions of the Internet Transactions Bill. Now, another issue that has arisen is the entry of foreign players, foreign entities who do not have a registered presence in the Philippines, but nonetheless are offering goods and services that are popular or widely patronized within the Philippines. Questions have arisen about the regulatory jurisdiction over such entities as well as consumer protection issues. So that is also an issue that the bill seeks to address. So first, about jurisdiction over foreign providers of um, online goods or services. So one of the questions that has arisen was because they do not have a physical or a legal presence in the Philippines, meaning that they have not duly registered with our SEC or DTI or other regulatory agencies. Then the question has arisen whether or not they are, because of their lack of a legal presence, able to avoid or evade regulatory jurisdiction of the Philippine government. And one of the things that the bill will clarify is that yes, the Philippine authorities may exercise regulatory jurisdiction. And one of the principles that informs the bill is the idea of holding such foreign players liable as long as they are purposefully availing of the Philippine market. A purposeful availment standard, as lawyers may know, is one of the existing legal standards establishing jurisdiction, legal jurisdiction over non-residents. And that is the principle that informs this bill. So one thing that the bill would do is ensuring that as long as the provider is purposely availing of the Philippine market, meaning that they are opening or making available their goods and services in the Philippines, even if they don't have a legal presence here. And you know that there are some of these providers who even very intentionally target the Philippine market through their advertisements, through the way that they market their products, etc. Perhaps even designing a set of products that are specifically designed to attract Philippine consumers. Now, in the Philippines and subject to applicable Philippine law, including the Internet Transactions Act. Now, another thing that the bill would do is to create presumptions as to who is authorized to engage in e-commerce in the Philippines. And the design has been that rather than requiring such entities to register again or to have an entirely different registration process in order to do e-commerce in the Philippines, rather, as long as one is already registered to do business in the Philippines using or relying on existing Philippine law, then they are already presumed to be able to engage in e-commerce in the Philippines. So this would include Filipino individuals who are licensed with the DTI as single proprietors. This would include corporations, one-person corporations, or partnerships that are duly registered with the SEC, cooperatives that are duly licensed with the Cooperative Development Authority, and foreign corporations that are duly licensed by the SEC to transact business in the Philippines. Now, as seen in the previous slide, even if one is such as, for example, a foreign corporation that is not duly licensed by the SEC to transact business in the Philippines, but as long as it is purposely availing of the Philippine market, that would be sufficient for Philippine authorities to exercise regulatory jurisdiction. And one of the regulatory steps that can be taken is to require that entity to follow whatever appropriate registration requirements may already be required by Philippine law. Another key feature of the Internet Transactions Act, and this will be discussed in perhaps greater detail by Asek Pacheco, is the establishment of the E-Commerce Bureau. And the idea behind the E-Commerce Bureau is that it would become the focal authority for e-commerce in the Philippines. The E-Commerce Bureau would be under the Department of Trade and Industry. But it would be one of the bureaus under the DTI. But it is designed to be the central authority or the central focal point for e-commerce in the Philippines. And within that mandate, it would carry the authority to promulgate rules and regulations governing e-commerce activities. Now, the way that it works is that this exercise of authority or regulatory jurisdiction by the E-Commerce Bureau would be ancillary to that of existing regulatory authorities. The E-Commerce Bureau would step in if any existing regulatory authority does not act or defers the matter to the E-Commerce Bureau. Among the powers of the E-Commerce Bureau also is the granting of subpoena power so it can duly exercise its regulatory mandate. Enforcement. So, consumer complaints involving e-commerce would be treated as such under the Consumer Act. That is the design of the E-Commerce Act. And when it comes to damages and penalties, it would still be the regular trial courts. Or rather, particularly criminal penalties. It would be within the jurisdiction of the trial courts. This is but at the same time, the DTI through the E-Commerce Bureau would have certain administrative penalties, as well as the administrative penalties that the DTI can already exact under the Consumer Act. But one novelty, one new introduction in the in the Internet Transactions Act is the idea that online e-commerce platforms may be solidarily liable with the online merchants, meaning that a online e-commerce platform may be liable to the consumer along with the online merchant who uses those platforms in order to sell their goods. But this solidarity liability would only apply in any of the following circumstances. So first, the failure to exercise extraordinary diligence on the part of the platform to prevent any loss or damage to the consumer. The identity of the online merchant and platform is the same. The platform knows or should have known that the digital products sold do not comply with law or violate other laws such as intellectual property rights, and they fail to take the necessary measures. The failure of the platform to publish details about the online merchant. The failure to examine products that are of a special sensitivity or interest to consumers, particularly food, drugs, and cosmetics. And these are products that otherwise relate to the life or health of consumers. And then there is if the online merchant is not duly registered with appropriate regulatory agencies and the platform permits online merchant to sell products. And the idea behind establishing solidarity liability of platforms is to provide for effective remedies on the part of consumers, because especially if the online merchant is located abroad, or have the details about the online merchant are vague, and that which would preclude the consumer from being able to run directly after that merchant. If any of these particular circumstances exist, at least the consumer would have a remedy that can be exercised against the platforms themselves. Because the idea is that platforms would or should exercise a greater degree of responsibility than that which is already provided under Philippine law. So that concludes my brief presentation, and I welcome any questions that you may have. Thank you, and good afternoon.